Hey there, it's Rob Ryder, and it's Saturday, May 7th, 2022. And today will be the 1, 2, 3 to remove a notice of pendency, New York style, having to do with how they do foreclosures in New York, where, like the first document that's filed is a thing called a notice of pendency that's actually filed with the county clerk, not the clerk of the court, although it could be the same person, right? It's at a different office. It's in the official records of the county, the same place where they filed the mortgage. So there's all sorts of things you may find in the official records. If you've never looked in your county, you should go look to see what's under your name, and because that's the record. So based on that record, somebody could take you to court. So what we're going to do is get the notice of pendency removed from the official records, and then there's no foreclosure case that can follow because there's no foundational document. And I showed some of this in my last video, and I'm helping Warren now get ready to go, do the deal, and so I thought it'd be easier to do it in a video than try to explain it over the phone. So hey, let's continue on. So I'm Staff Sergeant Robert Allen Bratluski, U.S. Army veteran, also known as Rob Ryder, and my email address is courtofrecord@aol.com. Fuck, Bob, you can't spell Army right. Hang on a minute. Can't go any further. We fix this. There we go. U.S. Army veteran. Court email, courtofrecord@aol.com. Yeah, that's correct. No S's on there. And before we go any further, if you can, will you help keep the lights on? You could do that by sending a donation through PayPal to robryder@aol.com. That's my PayPal name. If you don't have PayPal, but you had a credit card, you could send me a email to courtofrecord@aol.com and say, hey, Rob, why don't you send me an invoice for X number of dollars, which I would do through PayPal to your email address, and then you could pay with a credit card. Or you could just stick something in the mail. Robert Allen Bratluski, 10955, 14 Mile Road, Northeast, Rockford, Michigan, 49341. Any donation is greatly appreciated, so I'm asking. Okay, give me a second here, and we will look at some documentation and see what the law says and see what the judge said and see if we can combine all of these little facts together to, work in our favor. So hang on just a second. Okay, so a few generalized details, right, that what I'll be talking about today, I started talking about in my last video, which was Judicial Review and Trial de Novo, which you can find on Rob Ryder on YouTube, but Rob Ryder with 3 B's, ROBBBRYDER. So that's where you could start to see what had happened that's leading to this video today. And in New York, in the New York laws, it's under notice of pendency. Because what I'm going to show you is if you live in New York and you have a foreclosure, well, you can do the same thing, right? So this is the section of the law from the New York State Senate. Article 65 has to do with notice of pendencies. If you're in a foreclosure in New York, right, you have this New York State Unified Court System, electronic filing, right? So if you Google NYS courts electronic filing, you probably end up at this page. And if you hit search as a guest, it takes you to another page. Well, nothing's ever quite immediate. First, you got to tell me you're not a robot. And then you can get to this page and you can put in a docket number. So in our case, it's 2019-52422. Right, Penny Mac Loan Services LLC versus Shelley Jones et al. And if you click on case, right, it'll give you all the documents that have been filed in this court case. That you can click on any one of these, it'll open up, right? So let's click on the notice of pendency because this is the thing we're going to be talking about. And we see that they filed a document in court that was a 4-page document. Right now, again, this is in court, but first it had to be filed in the county. But this is how they filed it in the court. right? So they have this 2-page document they called a Notice of Pendency of Action, which is not what it's called in the law, so just keep that in mind. Then it gives a description of the property, right? And then this last page, which says Notice of Pendency, which is what the law calls it. And if we look at this Notice of Pendency, it has not been filled out. It's not been signed by an attorney, and there's nothing down here to take notice of, right? So it was submitted in, bad faith. Because if you read this little, warning sticker, pursuant to 22 NYCRR 130-1.1, the undersigned attorney admitted to practice in the courts of New York State certifies that upon information and belief and reasonable inquiry, the contentions contained in the annexed document are not frivolous. So if they didn't file this, then it could be considered a frivolous filing. Well, again, they didn't sign it. There's nothing on here. So, what they're really basing their claim on is this thing they put in called a Notice of Pendency of Action, which is just something they made up on their own that, isn't what the law says. So, but there it is. That's how it's filed into the court case. Now, if you wanted to see how it's filed in the county, right, because this is County of Dutchess, then you would go to look up Dutchess County. Where did I see this at? Okay, dutchesscounty.gov, right, document search. Okay, all right, launch document search application. But now you have to accept or not, so I'm going to accept. And you end up with this page here, and this will take me a second, so I'm going to shut you off and be right back. Yeah, okay, wasn't that hard to do after all. So you put in the name backwards, Jones Warren in this case. Search on it, and well, there's a number of things with Jones Warren, some with a G, some with a W, some with neither, yada, yada, yada. And at first glance, there's nothing on here that says Notice of Pendency, but you have all these types: mortgage, assignment of mortgage, clerk's minutes, assumed name, so forth, clerk's minutes. Well, it's this clerk's minutes that when you open it, it takes you to the Notice of Pendency. Right? Now, this is an unofficial copy. So if you were just to copy this, put it in court, it wouldn't have any value because it would be hearsay evidence. Right? It's not official. It doesn't have a seal on it. It's not been certified by an officer. But if you went down and paid to get a certified copy of this, well, then it would have those things, and you could enter it into court. And in court, it would be seen as foolproof evidence or self-authenticating evidence or whatever the proper term is. But, it complies with the federal rules of evidence, rules 901 and 902, which, the state has the same thing. They just may use a little bit different numbering system, but, it all lines up with each other. So, and I have with that to look at. Hang on a second. All right, so that's what Warren did. He went down and got a Notice of Pendency document, right? Document number 2. And there's those pages there. And, well, here's the seal from the clerk, right? I certify that I have compared the copy of the original thereof, filed and recorded in my office, and the same is correct. Transcript thereof of Notice of Pendency, right? Witness thereof. And they use green. That's interesting to use a green color. I don't know why. It's not black, not red, not blue. Why they use green? Is there something to do that? Because I've seen red ones before. I haven't ever seen a green one. But here's the county seal, right? So now this is a certified copy of a public record. It meets all the criteria of the federal rules of federal rules of evidence to be submitted as evidence without anybody's permission or anything else. It's self-authenticating evidence. It is what it is because it has this seal on it. Okay, and then it had a description of the mortgage premises, and then the last page is the Notice of Pendency, which is all blank. All right, so now we have an official copy. We can go to court and complain about it. which is what we tried to do just by asking for a, what was the name of my last video? It had something to do with it. Right, judicial review. We asked for a judicial review of the Notice of Pendency. And that caused something to finally happen, and this is the thing, because it did, putting in a judicial review in a tax case made something happen, where now it's going to trial, which when you think about it, well, that really is a judicial review. So until then, nothing had been happening, right? We put in a judicial review, now it's going to trial. Well, that isn't quite what's happening in this case, but it did get the judge to write this thing called a clerk's notice. And so let's see what the judge had to tell us. Okay, so the clerk went on to say this. Here's the index number, 2019-52422. Right, and this is document number 146. So if you went to the website I showed you, put all that in, you could have your own copy to look at. Right, and it's talking about a decision in order that the judge put in on February 18th. And so a little history in this case, because it's been going on since 2019. 6 months or so ago now, Warren put in a notice of constitutional question based on a video I had done. And although in the answer that came from that from the judge, you know, she poo-pooed the idea that we had done that, she went on to say, you know, what the plaintiff had actually done wrong, which was the filing that the plaintiff did with the, and she picked, that the plaintiff did with the Department of Revenue for the state. And so she, you know, she didn't use the word dismiss, but it was, you know, she dismissed the case. And an attorney that Warren knows came up to him later and said, you know, whatever you did, man, that was monumental. Well, as monumental as it was, a month or so later, a bigger attorney firm from downtown Ground Zero Manhattan now has the case, and they're asking the court to reopen, to re-argue the case, which happened, right? And then because of that happened, the judge had wrote this order, and this is what she had said, right? That the plaintiff was ordered to file a motion for summary judgment on April 6th. The defendant was required to file their opposition and or cross motion by April 27th. The plaintiff has complied. However, even though the defendants were aware of the above schedule since February, they requested an adjournment of the filing of their opposition cross motion at 4:36 p.m. on April 27th, the last possible moment. Good for us. Nevertheless, as the defendants are pro se, the court will grant defendants until May 18th to file any opposition and or cross motion to the plaintiff's summary judgment motion. Plaintiff's reply should be filed after that, then by June 1st. Okay, so there's a lot of reasons that we got to the last minute, but it doesn't matter. We're past that now. We're here today. And so here today is what she said. The court notes, this is the rest of what she said after she took a breath, right? The court notes that the defendants have also filed documents entitled a praecipe and a petition for judicial review. These documents are not in the form of a motion, right? So they didn't fit the idea of the motion she said to file. They do not include a notice of motion, and it does not appear the defendants paid any filing fees for the motions or for motions. So, you know, whatever we filed, although they were a praecipe and they were a petition for judicial review, they were not a motion because they didn't have a notice. We didn't pay a fee. The court will not consider any document that does not comply with the New York civil practice law and rules. Now, you would think they're telling Warren that, but actually they're telling the clerk's offices that because the clerks are the ones taking the paperwork and filing it. And they're supposed to know what it is they're looking at and say, oh, that isn't done right. As we'll see, I'll show you what it says right in the law. So, right now she's putting them on notice, right? This is like a judge's order said the court will not consider any documents that does not comply with New York's civil practice law and rules. So any application, right? Any application, didn't say motion, didn't say petition, didn't say an application of the defendants should be filed in accordance with the above schedule and New York law. The defendants are reminded of the importance of legal counsel. You don't want an attorney to represent you. You want legal counsel, right? Go ask for legal counsel. could do that, but Warren doesn't want to, so we're going to go step 2, which is in the event that they choose to continue to proceed pro se, they're advised that the New York State Court maintains court help centers, which may be of some assistance. Okay, well, maybe we can use them then. So anyways, what came out of that? Well, she recognized that we filed a précipe, which meant she read it, right? And the petition for judicial review, she read that. And they're not in the form of a motion, and they do not include a notice of motion, so they can't be considered a motion, right? They're not procedurally correct. We didn't pay a fee. So it can't be looked at by the judge because you didn't pay the frickin' fee to have your motion looked at by the judge. Now, we weren't trying to put in a motion. We're trying to put in a précipe, which is supposed to be directed to the clerk to do something, which was to tell her to take the notice of motion out of the court case. And then a petition for judicial review to the judge, telling the judge, hey, judge, look at this notice of pendency, and look what's wrong with it, right? 1, 2, 3. So she did look at that stuff, but said we didn't, follow the procedure, so she can't do anything about it. Her hands are tied, but then she gave some legal advice. Right? Any application of the defendant should be filed in accordance with the above scheduled New York law. Defendants are reminded of the importance of legal counsel. Yada, yada, yada. Okay, so let's look at why we're here. Hang on a second. Alrighty then. So I said, okay, well, how about I just Google New York court application or applications, something like that. And I found this page here where it talked about ex parte applications. Okay, well, it's called an application. That's what I want to do. An ex parte means I don't have to have anybody's permission from the other side. I can just go to the court, right? Do ex parte. So this is a little bit hard to read on here and, point out the stuff. So I'm going to go to where I copied and pasted it. But I just want to show you that, it's newyorkcourts.gov. And this is the first Judicial District, Supreme Court, Civil Branch, New York County. Which this isn't where Warren is, but New York has a unified court system, right? So what's good in one division or district is good in every district. It may be the room number changed. Like this says all ex parte applications will be submitted to the ex parte office, room 315. Well, that's good to know. There's actually a separate office for ex parte applications. Now, I don't know that's how it is in Dutchess County. My point is, right, that if you take this, if you were to copy and paste this and take it into your help center and say, look, this is how they do it in this district. I want to do it here. Who do I need to talk to? I believe they'd have to tell you. Because, they're going to send you up here, ex parte, they go to this one, except commercial division. They have to go down to a different floor. They get you running all over the place. And then you end up in room 160 to pay a $45 fee. Third floor, first floor, da-da-da-da. Right? If you're not going to the third floor first, probably did it wrong. So let's look at this here. I want to show one other thing, because on this page, right after it goes through all these things that these ex parte applications can be used for. And so an ex parte application is really just like an ex parte motion, right? But it's not called that. It's called an ex parte application. And what we're going to be applying for is an order to show cause. This keeps going down. We get the mechanics liens, right, for notice of pendency. A notice of pendency may be filed in any action which judgment demanded would affect the title to or possession, use or enjoyment of real property. Notice is filed at the office of the New York County Clerk for the property situated in New York County. It may be filed on or after. Yada yada. Anyways, I got this on another page. I'm just showing that this is one of the things that was covered. And right, the court shall or may issue an order canceling the notice of pendency under circumstances set forth in some particular section of law. And it gives one that is. Order shall be made or shall be issued upon motion of any party aggrieved. Okay, so let's take a look. It's a little easier on this. Yeah, here's that same text talking about notice of pendency. We get down here to where it says that the court shall or may issue an order canceling a notice of pendency under the circumstances set forth in CPLR 6514, either mandatory or discretionary, though not listed in this section. A clearly valid reason for seeking to cancel a notice is that the action is not proper, one, for use of the device under CPLR 6501. Okay, some book written by David Siegel or whatever. So, now look, this was put in, this is right off the courts, or off the government website where they put this little thing in here about Dave Siegel. Right, so, right there, David D. Siegel at 357. So whatever, that's like a reference to some book written by David D. Siegel. That book probably has some really good answers in it if you're really into that level of detail. But, the fact that they would put it into the middle of a paragraph in a government website is, kind of interesting. So the order shall or may be issued upon motion of any party aggrieved, which shall be brought on by order to show cause. Okay, well, how do you get order to show cause? You have to apply for one. The order canceling a notice may direct the plaintiff to pay the costs and expenses occasioned by the filing and cancellation, as well as cost of the action. And cost, when you go look at the definition of cost, it's everything that that the aggrieved party could have collected. Expenses of a suit, which may be recovered by law from the losing party. Right, so it's based on the statute of Gloucester. Yada, yada, yada. Right? This has been adopted substantially in all the United States. Okay, so ex parte applications. That's what we're going to do. We're going to apply ex parte for an order to show cause. Why the notice of pendency shouldn't be removed. If the judge agrees, then the judge can, find in your favor and give you cost because you just won the case. All right, so all ex parte applications are to be submitted to the ex parte office, which, again, that's room 315. Now, this isn't for Warren, right? This isn't Dutchess County. This is just how they did it here, but going to be some similar thing. So, right off the bat, they're talking about ex parte office. So that's what I'd be asking for when I would go to my New York County. Where's the ex parte office? Or your court for the county. I think he's in the 9th Judicial Circuit or 9th Judicial District. Or this is like the 1st Judicial District, right? So whatever judicial district you're in has got an ex parte office. Where's it at? Attorneys submitting proposed orders to show cause or ex parte orders in electronic file cases must e-file such submissions as required by the protocol or courthouse procedure for electronic file cases. Generally, a request for judicial intervention must be filed if an ex parte application is the first instance of a request for relief in an action or proceeding, or if the application is a self-contained one. See, because you don't even need to have a court case to go and get order to show cause. That can be the document that begins it. But they have this thing where they want you to pay a request for judicial intervention, which is a fee of like $95 or something like that. The first person to open a case has to pay it. And, Warren's already been told this has been paid, so he wouldn't have to do this. But if you were going to get an ex parte application for an order to show cause, and you didn't have a court case already, then you would have to pay that. And while you're here, they would be, assigning a court case number. I guess it'd be an index number to your case. Order to show cause. Proposed orders to show cause brought on in cases other than in commercial division must be submitted, into a particular room, and then you must take the proposed order to show cause, shall proceed to the county clerk's cashier's office, room 160, and pay a $45 fee. Well, that's what it costs to have a motion heard. So this is the motion fee that the attorney's talking about. It's just you don't need to go to the other party and put them on notice you're going for a motion or motioning the court for the order, or you could do it ex parte. The ex parte office records the proposed OSC in the court's computer system, as well as the names of the attorneys for the movement and other attorneys, if known and not previously recorded in the system, and assigns a case if previously unassigned. Right? Well, in this case, there is a case assigned, so, but that's just, if there wasn't and you were going to get one, well, this is how they would do it. They'd take care of all that shit for you, I guess, in room 160, when you went to the county clerk's office and paid your fee. The ex parte office also reviews proposed orders to show cause for form in a process similar to the initial examination of motions on notice by the general clerk's office. Well, I think that's exactly what is happening here with the this court notice. Right? The court will not consider any documents that did not comply with New York City practice rules. And they had way out of that until they were told they had to pay attention to it, and now they've been told they got to pay attention to it. So by they, I mean the clerk's office, right? They'll just take anything you give them and file it in the court case normally, but well, now they can't do that. But anyways, that's the general clerk's office. But the ex parte office reviews orders to show cause for form in a process similar to the initial examination of motions on notice by the general clerk office. All ex parte applications must comply with CPLR 2217, CPLR 6313, precludes ex parte issuance for temporary restraining order against a public officer, board, municipal corporation of the state to restrain the performance of statutory duties. And we're not doing that, but if you were trying to get the state to stop something, right, a public officer, board, municipal corporation, like the school board, whatever it is, you could go and get an order to show cause. You would just have to make sure you filed CPLR 6313A. Right? Just do what it says, and you could get an order to show cause to stop a public officer, board, or municipal corporation if you had the proof. To restrain the performance of statutory duties. Well, okay, they say, well, that's their duty. And you can say, well, no, you haven't taken an oath of office. It's not your duty. You're usurping the office of a public officer. Because, again, none of these people have an oath of office. Right? So that'll be in another video. It was interesting that that's where it was buried at. Okay, further, under some other rule, provides for notice except certain circumstances. Right? So, okay, well, then, if they say you have to put them on notice, well, then you do. But again, they have to review for form to make sure it's been done right. The clerks will advise the attorney who presents an OCS of any defects therein. Right? So you take it to the clerk, they're going to tell you what's wrong with it. Then you go fix what's wrong and bring it back. But they just can't say it's wrong and give it back. They got to tell you what's wrong. Right? They first of all, they need to know it's wrong, because they can't submit anything to the court that's incorrect. And so if you have it done properly and put in, well, then the judge is going to see it. And if the clerk's office says it's wrong, they have to tell you what it is. You can go fix it. The clerk will not purport to reject a proposed order to show cause, except as provided under this other rule, a statute or rule, or a specific order of the court. Well, that's why I say the clerk's notices. Right? The clerk's notice said, basically, clerks don't file nothing, or court notice said don't file nothing else unless it's been, been done properly. And that would be the clerk's fault, because they're the ones taking the paper. If counsel insists the OCS be processed immediately, regardless of advice of the clerk on the papers contain defects, except under the circumstances indicated, the clerk will process the papers. Okay, so, take it to the clerk. Here it is. I want to do this. And let them tell you if it's right or not. If it's not, they have to tell you what's wrong. Go fix what's wrong. Bring it back until they take it. Right? A proposed OCS, not an emergency nature, is reviewed expeditiously. If OCS cannot be processed within a short time, the presenting attorney should return as instructed and send a clerk to ex parte in order to deliver the papers to the assigned justice. We'll have to get into that part later. I don't want to go through all this. Right now, I just want to get them to take the thing. Right? But there is more about, now the proposed OCS, you've got the application done. And now you need to have it heard by the judge. We'll get that figured out later. But right, so you can use an order to show cause with a notice of pendency to have a notice of pendency removed if you can prove that under CPLR 6414 A or B, right, there's a reason to do it. Well, let's look at some of this other stuff here then. Some of these rules are talking about. Remember where I put them. I probably should just do these right next to each other. Right, CPL2. Right, the ex parte office reviews proposed order to show cause for form in a process similar to the initial examination of motions on notice by a clerk, by the general clerk office. All ex parte applications must comply with CPLR 2217B. So first thing is, go look at 2217B. There's 2217B or 2217, right? Prior motion, ex parte motion, transfer of motion. It says an affidavit, an ex parte motion. An ex parte motion shall be accompanied by an affidavit stating the result of any prior motion for relief and specifying the new facts, if any, that were not previously shown. Now, although we did try to file paperwork before, it wasn't seen as a motion, right? So, we don't really have this stating the results of a prior motion, but we do have new facts. And our facts are that what was filed wasn't signed by the attorney. And that's an act of bad faith. Right? So, Warren's will need an affidavit as part of his ex parte motion package laying out the facts. And it just so happens that, hey, they have a form to look at, right? Affidavit in support of an order to show cause. Now, this says Civil Court of the City of New York on it. But, hey, just scratch it out and put the name of your court in there. Right? County of, whatever the county is, index number, everything else is the same. Right? I'm a party, plaintiff, petitioner, claimant, defendant, check. I request the court issue an order for, check. Defense claim, right? Whatever your claim is. Prior order, don't have one. Right, so anyways, we'll get this thing filled out and submit it as, to take care of the requirement of having an affidavit in order to support our order to show cause. Right, section 2217, affidavit on ex parte motion. That was what that was all about there. Okay, well, we can do that. And then we'll go down here to what it is we want to do it for, which is notice of pendency. Let's see. How many of these I got to go through? How did I put these on here? Okay, because it talked about this other section, if you want to need this temporary restraining order, which we don't need, right? So, but if you did, then you would have to use that section there. Again, that's up here in this, going through all the different parts to get a notice, to get an order to show cause, right? But we're not looking for a temporary restraining order. But you might be if you're trying to get the public officer, board, municipal corporation of the state to stop doing whatever the fuck it's doing, because they don't have the authority to do it because the person doing it didn't take an oath of office. So, it's a big deal, but it's not in this particular case. That's for later. But this is what you need to do if you want a temporary restraining order. You got to file this section here. Okay, then we had calendar motions, which is another thing it talked about. And so really all I have done, right, is I've go through here, find all these different things it says you need to do, make a copy of them, right? Copy, paste, go look in Google, find it, whatever it is they're talking about. Put them all on a piece of paper. Pretty soon you get all these different rules written down of all the things you might have to do to get something done. Right? 2102, filing of papers. Well, whatever it says to do. Yeah, but, really isn't something I want to do right now. Just showing that these things are in there. We have to go through them all. But then we get down to this portion here where it talks about motion for cancellation and notice of pendency. Well, now we'll pay attention because this is what we want to do. This is in Civil Practice Law and Rules, Chapter 8, Article 65, subsection 6514, motion for cancellation and notice of pendency. Mandatory cancellation. The court, upon motion of any person aggrieved, right? So it could be ex parte application because that is a motion. That's lowercase m motion. Uppercase m motion would be a particular thing called a motion. But an ex parte application is something that moves the court. So it's a motion. You got to pay $45 to do it. Well, that's the motion fee. So it's a motion. It doesn't need to be called a motion to be a motion. So the court, upon motion of any person aggrieved and upon such notice as it may require, shall direct any county clerk to cancel a notice of pendency if service of summons was not completed within the time limited by section 6512, or if the action has been settled, discontinued, or abated, or if time to appeal from final judgment against the plaintiff has expired, or if enforcement of a final judgment against the plaintiff was not stayed pursuant to 5519. So for all these different reasons, there could be a mandatory cancellation. And I'm going to say one of these right off the bat is, well, there never was a proper summons done. Because the summons would be issued by the court, and that isn't what happened. Right? So that's one reason. But they had this discretionary cancellation also, that the court, upon motion of any person aggrieved and upon such notice as it may require, may direct any county clerk to cancel a notice of pendency if the plaintiff has not commenced or prosecuted the action in good faith. Right? Well, right now he has a frivolous filing because he didn't sign a paper that said it's not a frivolous filing. So that's bad faith. Right? He's supposed to sign right here to say this is not a frivolous filing. And he hasn't done it. And we're not taking notice of anything. It's all blank. Well, that's an act of bad faith. So there's no reason you can't, cover both of these in the same affidavit to say that it's your belief that there was never a proper summons completed within the time limit of this section, and let the judge go look. Right? Because like in Michigan, for there to be a summons, it has to have a court seal on it. Well, that's not on the summons they put into Warren's case. It was just a piece of paper attached to the complaint, but I don't know he was ever served properly. And I believe you have to do it within, this is the thing about 6512, you have to do it within 30 days or something like that. We'll see if we can find that. But, what I'm going to hang my hat on is this discretionary cancellation. I'm going to say it was not done in good faith. Right? So order to show cause that the plaintiff's notice of pendency was not filed in good faith. Right, for the following facts, it wasn't signed and there's no information on it. Well, then you can have a hearing on it. Yeah, here's a service of summons. A notice of pendency is effective only if, within 30 days after filing, so within 30 days of filing the notice of pendency, a summons is served upon the defendant, or first publication of the summons against the defendant is made pursuant to an order, and publication is subsequently completed. If the defendant dies in 30 days after filing before the summons is served upon him, publication completed, notice is effective only. Yeah, well, we don't have that problem. But there it is, right? They got to do it within 30 days. So, you could just say that you don't believe it happened, and then the judge has to go look at it and say, yes, they did, and show that they did, or agree with you, well, no, they didn't. And, okay, cancellation by stipulation. Well, we're not going to worry about that. We're just going to go ahead and get rid of it with a order to show cause. In this 6th undertaking for cancellation, notice pendency, security by plaintiff. Undertaking for cancellation, notice pendency, security by plaintiff. If in an action other than a foreclosure action as defined in subsection B of 6516, which talks about vacant property, so, that section doesn't apply to what we're doing unless they, coerce you out of your house and then they say it's vacant and then they could, which is what I believe they do. This is why they have to get you out of your house so they can claim it's been abandoned or vacant, and then, goes under a different set of rules. The court, upon motion of any person aggrieved, and upon such notice as may be required, may direct any county clerk to cancel notice of pendency upon such terms are just, whether or not judgment demand would affect specific real property, if the moving party shall give an undertaking in an amount to be fixed by the court, and if the court finds the adequate relief can be secured to the plaintiff by giving such undertaking, or in such action the plaintiff fails to give an undertaking in an amount to be fixed by the court, the plaintiff will indemnify the moving party for damages that he or she may incur if the notice is not canceled. Well, I was reading that an undertaking, I don't know if it was on this page or not. No, shoot, where do I have all my definitions? Right, that an undertaking is an engagement by one of the parties to a contract to the other, and not the mutual engagement of the parties to each other. It's a promise. Well, you would think an undertaking then is like an oath. Right? It doesn't have anything to do with money, it's an oath. Oath, vow, or promise are all the same thing. But that's what they were supposed to have done. Or I should say that's what they could have done, right? Is under this section here, you can get in such action the plaintiff fails to give an undertaking. Does that mean to take an oath or pay some money? In an amount to be fixed by the court, that the plaintiff will indemnify, insure the moving party for damages that he or she may incur if the notice is not canceled. Right? So if you lost your house when something should have been canceled, it sounds to me like you could go back and get damages because of what happened. So, that's a different situation we're in now, but I would say if you'd already lost your house, you could do this, right? We haven't lost our house yet. Our house. Warren hasn't lost his house yet, so we're just going to go do the simple thing and try to get a motion for cancellation of notice of pendency, and do it by an ex parte application for an order to show cause based on we do not believe that the notice or that that Warren was properly summoned within 30 days of the filing of the notice, and number two, that the notice appears to be improperly to have not been filled out under discretionary cancellation. Right? So it's not being prosecuted in good faith. But all this goes back to the fact that to do this, you have to do whatever it takes to do a ex parte application. And in New York, they're good enough to have it written out. Right? If you're going to go do this, you're in New York, you need to say, where's the ex parte office? When you go into the clerk's office. Because that's where you need to fill the paperwork out. And that, according to this, they have to make sure that it's been done right. does it say that? Yeah, the ex parte office also reviews proposed OSCs for form in a process similar to the initial examination of motions on notice by the General Clerk's Office. Well, now the General Clerk's Office has been put on notice, so if Warren were to file a motion there, you know, the way you would normally with a notice of motion and all the other bits and pieces, well, they would have to make sure he did it right. Because we're going to the ex parte office, well, that's a different office than the General Clerk's Office, and they have to do it all the time, apparently. Right? The ex parte application must comply with CPLR 2217B, which means you have to have an affidavit. Okay? An affidavit in support. And again, if you're in New York, well, they have one already made up. Right? If you Google affidavit in support of order to show cause, New York, it will lead you to this form. And I'm just saying, well, you're going to have to get rid of this line here. Right? I just cross it out and put in whatever court you're in. You know, it's in some particular county, so, well, let's look at Warren's real quick. So, right, Duchess is, Warren's in the Supreme Court of the state of New York, County of Dutchess. All right, Supreme Court of the state of New York. Just cross it out, write it on top, County of Dutchess. Fill it out. Everything else looks like it's fine, right? Got to go before signature of court, employee, and title. Well, there you are. So do it before the a court officer. Don't go to a notary. Take it and have it done by a court employee. And right, so that and your facts is what you need. And you could go and challenge this notice of pendency that's been put into the official record of the county, which is the reason, you know, the official record says there's a notice of pendency, there's a court case going against you. But it's not been signed. So we'll leave it that there for a second and talk about the other document that you'll find if you own a house is you'll find a copy of your mortgage in there in the official records. And I'm thinking that we can get a copy of that because you get an official copy of that also. And this will be in my next video, what I'm talking about right now. But that if you had that, because it is wrong, you could take them to, in Michigan, you've taken the small claims court because it violates the Consumer Protection Act. And you can have actual damages of $250 plus cost plus declaratory judgment plus. All these things are on top of the damages. But what you're really trying to get is the court to agree to give a judgment that the mortgage is unlawful. Because once you have that, well, you can get anything else you need. But, I'd say that to have all the documents up, and I would just leave it there. Okay, that's really all I had to show today. Was I'm going to try to help Warren get this done next week, and we'll see what the powers that be have to say after we do this. But we're really just trying to comply with this court notice, right, which is in this case. So if you're in New York and want to kind of get an idea what we're talking about, go to index number 2019-52422, where the judge is saying that the court will not consider any document that does not comply with New York civil practice laws and rules. Any application of the defendant should be filed in accordance with the above schedule in New York law. That's what we're going to do. And all this stuff is, this is your starting place. If you're in New York, is just ex parte applications, New York courts. And you probably end up with this page, or maybe your own county or district has one. But this is the one I found, and it'll tell you what you need to do. Okay, very good. Everybody have a great weekend, and see what next week brings. See ya.